The union government is set to challenge the order by the top court about the release of the 6 convicts in then Prime Minister Rajiv Gandhi's assassination. This, remember, has also become a mega political face-off. So what the union government has done is that on Thursday, they said that the Supreme Court order is legally flawed, that the remission passed without affording it an adequate opportunity to hear. Government has sought an approval to argue against the release of these killers. Congress is responding to this, calling this a case of belated wisdom dawning. Hitting out at the BJP party's General Secretary K.C. Venugopal is questioning what is the point in locking the door after the horse has bolted. Remember, top court last week ordered the release of 6 convicts, all the 6 remaining, that is, including Nalini Sriharan, who were serving life imprisonment in connection with the assassination of then sitting Prime Minister Rajiv Gandhi. Let's go across quickly to India Today's legal correspondent Anisha Mathur. Anisha, what precisely is the objection of the union government? How are they challenging it, and what happens in these cases when a top court order is challenged by the government?
Well, Pooja, so government has filed a review petition just last evening with regard to the release orders passed by the Supreme Court. Now, remember, when last week this order had been passed by the Apex Court, this was a surprise since it was the first hearing in the matter. The centre had not filed its response, and in fact, the court had ordered in its noted in its order that we are passing this order in parity with the May verdict in the A.G. Perarivalan case. Now, what the centre has said is threefold. One, that there is no parity with A.G. Perarivalan because he was only 19 and an Indian citizen. These people were older, were actually involved in the entire assassination attempt, and more importantly, 4 of these 6 are not Indian citizens but Sri Lankan Tamils, and therefore their release should have been considered by the government. The Supreme Court should not have passed such an order. Secondly, what they have said is this will create this will have international relations ramifications. Therefore, it is something that should have been left to the government to decide on whether these 6 would also get remission or not. Thirdly, what the court has been informed in the review petition by the centre is that the court should not have passed an order regarding remission without hearing the centre at all, because this is a very serious issue. It has serious implications as far as criminal law as well as the law and order situation in the country is concerned, because this case involves the assassination of a Prime Minister of India, and this has larger criminal law ramifications as well, since the court has in this particular case decided to grant remission without the government of India getting time to take a call on this issue. Remember, in the Perarivalan case, of course, the remission recommendation had gone from the state government to the centre. The governor had been sitting on it for several years, and that is why the Supreme Court had stepped in. Here, what has been said was that with regard to the other 6, the recommendation had gone earlier this year. So what was the hurry in passing such an order? The government should have been given adequate time.
So that's it's been challenged now, and we'll see how this case progresses. It's become a mega face-off as well. Many are asking the questions of why should they have been released, and what sort of an example does it set for many other such cases.